Hey, welcome. We're live. I think we're live. Let me make sure. We're having issues with X. I don't know. I heard someone say that X was now making you pay to stream. Is that right? Is that why we're having issues and get delayed every time I try to go live now on X? It's not letting us go live on X. We're not on Twitter today. We'll make do. We'll figure it out. Welcome to the show tonight. We got two great guests. The 3Ms are back. Let me clear my throat. We're also going to be live on a second news stream at 7 p.m. for the Canton Select Board meeting. So make sure you come check that out after this is over today. So let's get into it because the defense just filed some paperwork today. They just filed their response to the Commonwealth. And we have it up on the screen here. Actually, let's bring it up. There we go. This is page 1. We got how many pages is this thing? 10 pages. So we got a 10-page response. Let's bring in Mazza Media. What's up, brother?
Good evening. Thanks for having me.
Welcome back. I'm glad you're back.
Thank you. I appreciate it. It's another big day in the Karen Reed case with more motions being filed.
And let's bring in the expert, the legal expert, Attorney Mark Bederow. Welcome back.
Thank you. How are you? I'm out of bed for the first time in about 3 days, so I'm back.
You were sick, huh? Was it? You think it might have been the flu or COVID or something?
It wasn't COVID. So says the test, but something. But it's almost gone, but I'm functional now, so rough couple days.
We're glad you're back and just in time. You hit us up today and we're like, we should do something on this filing that happened. What's going on? What do you got for us?
It's pretty strong filing. It lays it all out. I think it really exposes the weakness in the DA's arguments. And I mean, you can appreciate this. I liked it, and I could be biased for this, but it seems to adopt a lot of the analysis that we talked about a week and a half ago. So, they emphasized the DA's focus on form over substance, which are the words that we kept using, that they're big on these technicalities while simply ignoring the fact about somebody's double jeopardy rights, which is a fundamental constitutional right. They talked about that big Bluford case that they wanted to rub their nose in and recognize the same thing that we had discussed, that it's just not on point. Same with that other Massachusetts case. So I think it was a very, very good response. I mean, we can get into the specifics in a minute, but I don't think it's going to change what the judge is going to do. I just think she's going to do what she does. But I think this does increase the controversy. They've really made a strong argument, and I think they have accomplished an interesting legal point, which is they have made the DA's argument, the waiver argument, a little more tenuous. I think they handled that very well by mentioning what we did, which was they kept focusing on the defense's reaction to the earlier notes and the mistrials, which has nothing to do with what happened at the very end. And what happened at the very end is the judge got the note, didn't ask any questions from the lawyers before they brought the jury in about what we're going to do. She just assumed we're going to grant a mistrial and did. And, you can say, I suppose, nevertheless, the defense still should have gotten out of their chair, screamed and yelled, but she didn't really give them an opportunity to. And that's a tough ruling to use to deny even expanding and exploring the issue when all these jurors are apparently ready to come forward in some capacity and say that we had an acquittal. The other thing that I think they handled really well was this, I think, misleading argument by the DA that because there was no verdict sheet checked off and, a verdict has to be published, that all sounds true and wonderful. But as we talked about a week ago, they're kind of ignoring the issue, and the defense kind of really I thought, pointed this out well. The issue is, but that's precisely the problem in why there's no verdict officially, because they didn't understand what they were supposed to do. That's not just being a moron who can't check off a box and then has regret and wants to change our mind about a verdict. What the jurors appear to be saying, at least through these attorney affirmations, is we didn't know what we were supposed to do because it was confusing. And as soon as we gathered ourselves, we're all standing around saying, oh my God, what just happened? And within 48 hours, you had a third of the jury reaching out to people, either lawyers directly or intermediaries, and trying to bring this to the attention of the court. So it puts a hell of a lot more pressure on the judge to basically choose form. You didn't stand up and object and invite the response, but that's your fault, Your Honor. And of course, the public criticism, or you can do what I would call the equitable and right thing under these circumstances, which is choose substance, which is to say, there's a real issue here as to whether she was acquitted on the most serious charge under the law. And shouldn't we at least be sure and then decide how to handle it? So they really did a good job putting the judge in the box, because if she denies this on the papers, they're going to get crushed publicly, all of them. And I think you also have to recognize what else the defense is doing here. And this is part of the chess versus checkers game I think they're playing. Everyone at this point, other than the 10 or 15% of the people who are the type of people who are going to tell you that she's guilty no matter what, they're science deniers, they're butt dial deniers, Google deny, just forget all of those types of people. But what they've done is basically make it clear to everyone else, she got acquitted. I mean, there's at least a good reason to believe that. And let's not forget that there could be a second trial, whatever the charges are. And the potential jurors in that case are watching the news that's happening now. And can you imagine the DA trying her for murder when there's a substantial likelihood that every single juror that they try to go through is going to be aware that a prior jury already acquitted her? So whether they win this motion or not, they are doing a brilliant job of strategizing and playing the long game for this whole process, and they deserve a lot of credit for that.
Now, I've heard you address this online and even on the show. If they lose this, if the defense loses this, they can't appeal right away.
No.
Unless she gets convicted. Then later on, they could maybe use that as grounds for appeal. Is that right? It would have to be after the fact, though.
Right. And before anybody gets excited, that's not really a Massachusetts thing. That's how the real world works thing. The defense generally does not have a right to what's called an interlocutory appeal, which is just legal mumbo jumbo for stopping a lower court proceeding by saying, that's great, but we need to go to an appellate court and get a ruling, and then we'll see it when that's done. There are very limited circumstances that allow that. That losing a motion on double jeopardy grounds is not one of them in Massachusetts. In fact, really the only basis in Massachusetts that a defendant could do is in a very unique circumstance that they got permission from a judge on the highest court in the state, what they call the Supreme Judicial Court there. If they lose a motion to suppress evidence, if a judge from that court says, I'm going to allow you to have this appealed now because it's so critical or whatnot. The DA has a right to certain interlocutory appeals because the case can't continue. So you will see in certain cases, if a bunch of evidence gets suppressed, like in a drug case, if all the drugs get suppressed, they can't continue. I mean, how can you prosecute someone for drugs when a court rules that they're inadmissible? So they would get the right to file an interlocutory appeal. And then if the appellate court reverses, then they would say, okay, you're back in, the drugs are back in, go back to where you were in that case. Or if the indictment were to get dismissed, they could get an interlocutory, if they lose this, the DA, they would probably have a basis to find a way to appeal this. But if the defense loses this, The reality is they're never going to appeal it. You're never going to hear from this issue again. And if you do, then it's real bad because that means she got convicted. But because she's almost certainly not going to get convicted, the reality is if this judge denies it, that's probably going to be the end of it because she's
Interesting.
never going to appeal because she doesn't get convicted.
Exactly. Mazza, you got anything on this?
I do. Page 4 of that motion had a very, to me, one of the biggest standout moments was basically what they had reported. Was basically, I'll read this here, just a sentence. According to one such juror, quote unquote, Juror D, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and count 3? And this is from Alan Jackson's supplemental affidavit, I believe, here. That stood out to me like a sore thumb, that this was on this motion, because it tells a very, very large story here that basically you had them basically rushed out the back door and thrown on the bus, essentially, with basically, it's a mistrial, declaring a mistrial, it's game over, that's it. And basically at the end of the day, taking no, and this was also talked about in this motion as well, the response, I should say, that basically they are arguing that there was no time permitted for the defense to basically discuss this, have any opportunity for the court or the judge to deliberate further or discuss further with the jury, not with the jury, but basically review further what kind of things have been thoroughly reviewed here, that if a mistrial is even necessary in the first place. And that's really where I looked at this thing and I said, this is the madness that we've all come to expect from this particular case. And when people like ourselves and everyone out there is saying it's a frame job, it's a cover-up job, and it's extending all the way now to a trial where it's declared a mistrial, and now we're hearing count 1 and count 3 were both definitive not guilty verdicts. And then we're basically seeing a judge basically say, mistrial, game over, that's it, see you all back here on July 22nd. And then I read this, what was said here in this letter, that you had jurors on this bus sitting there basically like, well, we declared her not guilty on counts 1 and 3. What the heck is going on?
I think also that vignette that you just read about the bus conversation serves another purpose. And that's the kind of thing that is designed certainly for the public to see and to make the judge very nervous, because that's a preview of some pretty damning testimony at a hearing, if there's a hearing. I mean, jurors coming in and testifying that we're on the bus, and one after another says, we're sitting here amongst ourselves saying, what do we do? They didn't get our verdict. And if you can, put up 12 jurors like March of the Chuckleheads, one after the other, telling the same thing, that's really devastating. And if the DA's argument against that is, but these are dummies who didn't know how to check a box, their argument is not even germane to the point. I mean, the point is we were confused because the instructions were bad. We didn't know what to do. Nobody told us what's going on. So of course we didn't check off the box. We didn't not do it because we have regret, because we did reach a hung jury. Somebody did hold out. We didn't know what we were supposed to do. Nobody gave us guidance. And then when we realized that we were not going to get that guidance and we were whisked out of there, the light went on. And for her to keep that out, I mean, the alternative is going to be, you're not going to get it under oath testimony. You're going to get that in interviews with NBC News and other people. And it's just going to be even, the problem's not going to go away. I mean, I think that's the lawyers making it clear. You can do this the hard way or the easy way. Either way, everyone's going to know that we acquitted her. But at some point, are we going to do this the right way? And are we going to choose form or substance? And the DA has stood up and been counted. They choose form. That's disgraceful in these circumstances.
Now, Monday, 2 p.m. is this hearing. We haven't heard anything, as far as I know, on what's going to happen at that hearing. Are they just going to ignore this whole thing and just shut it down and go on to the schedule of the trial? Or are they going to bring out witnesses, or will they schedule a second, like another hearing to bring out the witness? Like, how would this happen? Like, what would you expect, Mark, on Monday?
They're not going to ignore it. I mean, even if she says we're done with this, then she'll have to deny it. She could deny it on the papers. She could adjourn it for consideration and read the briefs and think about it. She could adjourn it for oral argument, which she almost certainly will not do, because as you know, I mean, certainly I can see she is very much against, grandstanding in her courtroom and does not want to have, Karen Reed's lawyers screaming and yelling with powerful oratory and whatnot about how double jeopardy is like just the most fundamental constitutional right since, the days of the Magna Carta and all of that stuff. So, I mean, look, I would not be surprised if she said, I'm going to table this, think about it, and then issue a decision. And that decision could be any number of things. The decision will not be dismissing the counts. The best case scenario for the defense, because this is a long process, would be her agreeing that we can go to the next step, which is take evidence or gather evidence and then decide if there's going to be a hearing. So if she decides the motion, it will be bad for the defense, because you can't grant and dismiss those counts based on the hearsay and the lawyer affirmations. You need to hear, and plus you need to hear from 12 jurors, because if one of them says, well, that I don't agree with that, I had not made my mind up, then this is over. Like you can stop the process. But, some people have said, well, why haven't more jurors come forward agreeing? And that's a fair thing, although who knows? But I would kind of flip that on its head and say, how come no one's come forward and say, I disagree?
Right.
That's I think
especially even like if you follow Aiden's reporting, he said the jury foreman, who was the ex-cop, he said that he voted for her to be guilty on that one charge. He agreed that the other two charges, we were unanimous.
These people spent 2 months together. They had a, emotional deliberation, sometimes contentious at the end, but as they all like each other from what we were told and all this whole process. They have their text chain, which, by the way, wouldn't that be fascinating evidence and all of this? My point is, those 12 people know what happened. And if there are jurors who have said to a man and woman, 12 out of 12 did this, it's hard for me to believe that one is now going to come forward and just to be a difficult attention grabber and say, I'm just going to say no and make it up. They're going to get crucified by the other jurors, not publicly necessarily, but they could be outed publicly by the other jurors. At this point, there's pretty good faith basis to believe that in their mind, they acquitted her. And if the question is, then why didn't they tell the court that? Then for the love of God, why not get to the bottom of this and have them explain why? And if the story is unsatisfactory for whatever reason, whatever. But again, is the judge going to choose form and wag her finger in David's face and say, you didn't stand up, and when she didn't even give him an opportunity to, and invite that pushback, invite the criticism?
That's what I'm afraid of. I think that she's going to shut it down on Monday. It's going to be nothing. It's done. It's like dismissed.
But it won't be done. It'll be done in her courtroom officially, but that thing will have a shelf life for God knows how long. And then what happens later? Let's assume they do retry her. Okay. What if they win the motion, meaning the DA, they agree to retry her, but they somehow come to their senses on this issue anyway and say, we're going to dismiss the murder count anyway because we just think it's not productive, not because we agree with your double jeopardy. How's that going to sit with everyone, given the response that they just submitted last week, when they're going to say later on, well, we really don't want a prosecutor for that count anyway, so who cares? Meanwhile, Karen is churning up more legal fees. You know, these motions don't write themselves. Okay. Lawyers are churning hours. These are not cheap lawyers, as you can imagine. You know, and I worked at a large law firm. I know how this works. This is not one lawyer billing on his own. This is a collaborative thing between lawyers and this and that. And it takes time to do research, time to write, and then edit and redraft and edit and edit and edit. And it costs a fortune to do all of this. And none of this has anything to even do with a potential retrial, really, like the merits of preparing for a retrial.
Got a question here. Does Fifth Amendment offense refer to incident or charge?
Well,
What they mean
you
by that.
can't be, I think what the person means is, you know, it can't be the same conduct. So, for example, if she gets tried for, let's just call it vehicular manslaughter while driving drunk, okay, and she gets acquitted of that count, they can't now come back under the same set of facts and say, we're going to charge you with DWI. I mean, you can't, you can't like literally pick and choose, because as they say in their papers, the law does not favor prolonged dragging out and making a person fight, the might, power, and wealth of the state in perpetuity. So if they thought their idea, a prosecutor, whether it's these people or anyone else, to just sit back and drip, drip, drip and add charges to the same set of facts, they're not going to be able to do that. They're going to have totally separate elements in a crime, and you can't just keep retrying the same event over and over.
Question here: if for some reason this goes back to trial, can the defense tell the new jury?
No,
they can't tell them about it. What happened?
This is you get in a lot of trouble. I mean, that's worse than the whole FBI thing from the first. No,
well,
but
do
again,
you think there's any chance that will change, the FBI thing? Because the jury seemed confused.
Maybe, but probably not. But maybe. But again, to go back to something I said earlier, this is the whole chess versus checkers. No, they're not going to tell the new jury that she was acquitted. But the new jurors are, either in your chat right now, watching the news, seeing this, reading the papers, and over the next course of 6 or 9 months, they're going to hear about this. So the cat is out of the bag. As far as the FBI, I mean, I know there was that discussion where some of the jurors said, "Oh my God, I didn't know." I don't know how she would handle that. It's the same issue, but the difference, of course, this time is they're going to be more prepared to deal with the federal evidence. They're going to almost certainly be allowed to talk to the ARCA guys and can maybe make it quite apparent. I mean, look, they may argue that there's no reason they shouldn't know at this point, but the DA will oppose that. And then I'm not sure why the judge would change her mind. The only thing I would say is that if one of their witnesses, blurts it out like the Brian Nagel kid did, maybe the defense would be more aggressive going around saying, wait a minute. It's out there. So let's stop it.
Now, the prosecution kind of pushed back on the defense, even talking to the jurors, it seemed like.
Yeah, let's call it what it is without using the words, because they're needlers. They're like, they dance around the margins. They're like, they don't even have, I'd respect them more if they flat out said that they violated ethical rule, whatever, and ought to be sanctioned for this outrageous misconduct. Now, I think they don't do that because it's kind of stupid. And we had talked about how they're basically asking these lawyers representing a client effectively hang up the phone they use that analogy that we were talking about, that we're supposed to not listen to jurors who call us and say that we, acquitted your client of murder. Moreover, I think the lawyers did a very effective job in pointing out, the ethical rule says they're not allowed to ask them about, what went on in deliberations. Okay. But when the jurors are calling them and saying, we had an acquittal, that's not necessarily asking them about what went on. That's the juror telling them what the result was. So they're not going to get sanctioned for this. That would be outrageous. But
Mazza,
yeah.
you have any comment?
Yeah, is there any reason why the rest of the jurors that see what the other 4 jurors that came forward, is there any reason why, beyond any kind of levels of fear, let's just take fear out of the equation, hiding out of the equation, is there any reason why they'd either remain silent or not talk to the defense the way the other 4 jurors that we know of have?
You know what? I don't know, because there are 12 different personalities that none of us know. I mean, if you walked by in the street tomorrow, you wouldn't really know who they were. I mean, I can't remember faces even from being there one day.
Yeah.
And I mean, I'm vaguely, but not specifically. Some of them just may be more outspoken. Some people may be quieter, shy. I don't know. I mean, couldn't even tell you. But to me, yeah, you'd want to hear that 12 of them come running to the defense of the court saying, this is crazy. But I still turn that on its head and say, more interesting is why there are 0 saying, no, we're being misrepresented. And no one has done that. And you're going on 2 weeks of this, I think.
Mm-hmm.
Yeah, and you think the foreman too, like that's the person that was writing the notes. You
right?
If they're not saying it, they're saying the opposite. They're saying that not guilty on those 2 charges. The foreman. So
the foreperson is the most critical witness of all here, because only he can literally explain why I didn't check the not guilty box. And I got to tell you something. It is the same color as the judges, isn't it? This Yeti. Somebody's laughing. Yeah. This is what you get when there's nothing left on the shelf at LL Bean, unfortunately.
I like that color. That's a nice lime. Is lime green?
It's kind of like a limeish, tealish green. You know what? When you're walking down the street, exercise, it's not.
Yeah,
anyway,
just slap a Celtics logo on there and you'll be all set.
Go.
Yeah, exactly. It would make it a little more tolerable.
Yeah,
but
right.
And like that, I've been completely disarmed and forgot what we were talking about. Something about
the juror or the foreman.
Yeah. I mean, only he can literally state with firsthand knowledge why I did not check off the box. And he will be so credible for a couple of reasons. Number one, to the peanut gallery, because, she picked him, which I'm telling you is nothing. But that ought to satisfy a lot of people. But also, my understanding is based on him talking to Carney, right? So he says, I assume he did, that he was one of the guilty on count 2.
Yes.
Which kind of makes him more credible when he says, that's wonderful. We acquitted her on these 2 counts. That's the key witness right there.
Bingo. Yeah, I gotta feel like he's the one. And he was law enforcement too. Like law enforcement, even like a patrolman, especially a patrolman, they get taught to like be precise.
Box if there's an acquittal, and he didn't, and he's still saying it was an acquittal. I would damn well like to hear his explanation for why. And you would think that a reasonable prosecutor and judge would too, just to make sure that we don't make one teensy-weensy little kind of unimportant mistake, such as retrying a woman acquitted for murder. I mean, how that doesn't enter their thought process to even acknowledge that in their response, meaning the DA, is just disgraceful.
Mazzy, you have anything on that? Or do you want to?
Yeah, is there any, just to maybe take the conspiracy theory road here and just maybe, theorize anything? Is there any way a 4-person could, write things on a note to the, bailiff that's handed to the judge that might be on there that's unbeknown. I'm not speculating in terms or alleging. I'm just saying, is it possible that, you know, a foreperson that felt different than the jury could write different things down before it's handed, you know, over to, you know, past second hand of the judge? Is there anything that would ever be a level of concern in that? Or is there, the other
No.
fellow jurors have more ability to look over it?
No, because the judge reads the note in their presence in the courtroom, and presumably somebody would say, "Whoa, whoa, whoa, that's not
Yeah.
what he said."
Okay.
No, no.
Now, with that said, we know that the defense has written in their motion that the jury members were concerned about the judge. So therefore, you would say that we can be confident that what the foreperson wrote was in line with what the other jurors had basically deliberated on. And basically, at this particular point, we could probably look more towards the judge, just like the defense is basically stating in this motion, or response rather, and that this would basically indicate that the judge here really has the finger pointed at them primarily. Is that accurate?
It doesn't have to be a situation where the judge did anything wrong per se, other than give bad, confusing instructions. The problem here is this, and the defense did a very good job pointing this out, which is another thing we had discussed last week, and they really, really were good on this, which is the only count that had lesser included offenses was count 2. Okay. And according to the jurors now, those are the only counts that, meaning the sub counts of 2, that they were struggling on. So it makes perfect sense that there is a reasonable interpretation of their "we are hung," that they were hung among the count 2s, not 1 and 3. Now, in all fairness to the DA, there is a perfectly reasonable view of that note that could be the opposite. I don't think it's an unreasonable thing to say when they say that we are hopelessly deadlocked, that, well, judge, that must mean across the board. But this is precisely the point of what evidentiary hearings are for. They are to find facts. And then once a judge makes a factual record and has a series of facts, you apply the law. And the DA is saying there are no facts to be had because no one from the defense stood up and said, "I don't consent to a mistrial." So they don't care about any of this. And Morrissey should be getting asked this publicly by, journalists from the newspapers and TV channels, certainly the ones that have legal backgrounds. They understand this.
Yeah.
And have him say, "You know what? I don't care about her double jeopardy rights. They don't object in Norfolk County. That's how we play." I mean, just take a position. Own it. Because that's what they appear to be saying, is that you screwed up, too bad, and that's it. And you're not talking about a piece of undisclosed evidence that maybe not would have mattered. Okay. You're talking about the most fundamental constitutional right imaginable. You, in theory, could have a woman acquitted of murder, retried for murder, get convicted. I don't think, all things considered, that would happen, and then spend the rest of her life in prison, even though she had already been acquitted.
Right. That's insanity.
Let's go back to that. Maybe let's just pretend that she was convicted
in a second trial.
Yeah. And then they appeal it. And because Bev didn't talk to the jurors, didn't do the investigation.
And the appeals bureau or these people in the Norfolk DA's office would say that's justice because no one objected before she entered the mistrial. And too bad. It's all fair. That's how we do it. And you know what? But couldn't they also think how bad this could be? You have to go to.
Couldn't they also put those, like, after they go all through all this BS? Let's say they get a conviction, it could get thrown out after the fact because she didn't do the basic investigation to find out.
It could, and the DA will take the position, okay, that the judge handled it properly by denying it on its face because the defense waived their right to be heard, notwithstanding, and the judge had no obligation, because it won't be Canoni at this point. It'll be somebody higher, an appellate court. And the judge had no obligation to look into this, make factual findings, because she made a proper determination that the defense consented to the mistrial by standing there like a potted plant when she basically took the jury out and said, okay, I got your note and I'm declaring a mistrial. Now, again, even after that, could the defense have jumped up and down and said, wait, yes, but should they be faulted at that point when it's done? No.
Wouldn't the defense not have any reason to really object to any of it at the time, because none of the jurors had come to them, and once the jurors came to them, it really alarmed them to want to
Right.
say something and write a
How would
letter?
they know
I
there
think
was
you
a
have to be careful with that argument, because
Okay.
if you start making a strategic choice not to object, in other words, it's a calculated, I'm not doing this, that's a waiver. Okay. That is essentially saying, I'm going to play this out, and if it goes the right way, use it later. So there's no way they're ever going to make that argument. Okay. I mean, that would not appear to a judge like to be clean hands. And I'm not saying that's what they did, by the way.
But it could be. I mean, in a way, like, because I thought about that too. Like,
The problem they have is this, meaning the DA. They're arguing that they waived a mistrial because right away, if you recall, when the jury's first note came back, Lally said, it's too early, send them back. And Yannetti said, no, you know what? Let's give them the charge, as if that's somehow ready to just let this disappear. Now, whether that was or wasn't, circumstances change. They did go back and deliberate. And the defense, just like anyone else, like jurors in Bluford, they're allowed to change their mind based upon any number of considerations. And the bottom line is, when the last note came out, they were not afforded an opportunity to be heard. And the judge just declared a mistrial. So it doesn't matter what he said before or even why. Okay. None of this matters. The bottom line is, they were denied the right to be heard. And again, even if you want to go down the rabbit hole and say they still should have on their own, sua sponte is the word we use, jumped up, done this. Are you really going to choose form, that, or substance, which is all of these jurors are giving a really troubling scenario? And is anybody other than the defense lawyers even remotely concerned about the fact that she probably, I say probably based on their representations, you still have to hear the evidence, but may very well have, maybe that's more fair, may very well have been acquitted. And now you haven't heard from the judge yet, so we're assuming, she might surprise you. But the DA is very clear. They don't care.
Yeah.
They in case you had any doubt, they are entirely comfortable with this process and could care less. And if the jurors contacted them 12 out of 12 and said, shame on you and this, they would say, hey, you never checked the box, beat it.
Yeah, they don't care about justice.
They don't care.
That's what it comes down to me.
They want Karen Reed's scalp. That's what they want.
Question kind of related to that. Do you think the checkers approach by the judge and DA signifies a focus on short-term results, and why?
Well, in all fairness, the judge has done nothing. I mean, she literally hasn't peeped a word other than, sealing the jurors' personal information for a period of time. So in all fairness, you don't know what she'll do. I kind of have a feeling based on other things we've seen. The DA, though, has stood up to be counted. I mean, they are on record embarrassing themselves. And I think everything they do is based on short-term survival. I think they are stuck in the proverbial dam with, 2 leaks and only one finger. And they are just trying to stop the dam at some point from bursting and coming down on top of them, which is inevitable in this case, isn't it? Anyway. But they are just trying to survive day by day. But you also have to recognize they're zombies. They don't care. Okay. When they got the ARCA stuff, they didn't care. When they got all the phone records of Proctor, they didn't care. When they saw all the butt dials that make no sense, they didn't care. They don't care. Nothing embarrasses them. They don't care about their credibility at all. They wanted to argue that they wanted a jury charge, if you remember, that the alleged abuse, I say alleged because it's not even proven, that Jennifer McCabe said she suffered at the hands of, a blogger, I think was the word she used, should somehow be held against in the jury room Karen Reed without any evidence whatsoever. They submitted that. You saw that jury instruction.
Yep.
They submitted that with a straight face. That was disgraceful. I mean, that was embarrassing. They wanted the jury to punish her on a consciousness of guilt theory for hiring a lawyer when a dirty, corrupt cop, as we now know, called her up about this thing. And at the time, he had already decided, I'm arresting her. God knows what he told her. You never heard Karen Reed's side of that conversation.
That's right.
You have no idea what he said to her. And you probably never will, not in the courtroom anyway, right? So, and they had the gall to say that the jury should know about that as evidence of her guilty conscience. Every single criminal lawyer and prosecutor, frankly, in a real DA's office was either laughing, crying, or shaking their heads saying, who are these people? And can they seriously believe what they're doing on national TV right now when they act like this? But these are the zombie types that you're dealing with.
It's about the jury instructions. Apparently, the website's been updated, and a mass court website's been updated the last 6 days about jury instructions.
If they updated it related to this, okay, and the issue that we're talking about, that's not evidence. You can't introduce changing, for example, when in a civil case where somebody gets run over, you can't introduce a trial 2 weeks later, they put up a stop sign to, that means they knew. But that would make me very uncomfortable. And if that's true, I would send that to the court and make the DA. I mean, that does seem like a damning admission if the adjustments are related to this, which I'm not aware of this. So I don't even know if it's that subject matter, but that would be really concerning.
Interesting fact.
But not evidence.
Yeah. It's very interesting to see what's going to happen on Monday. Because I just have that feeling she's just not going to do anything.
I agree. Auntie Bev doing Auntie Bev things.
Yeah.
This is such a no-brainer way to handle this. The way that if the judge ought to handle this is to say, I'm going to authorize the defense to develop evidence. Okay. I'm not ruling on anything. I want more information, and I'm going to authorize you change the order that either, and you can draft an order that lawyers only or an investigator with the lawyers, nobody else can speak to jurors if they so choose. No names, genders, ages, nothing to identify who they are. And then adjourn it a month or whatever and see what they get. And if it comes back that there's a couple of jurors who say it didn't happen, well, then it's over. But if it comes back where now you have 12 out of 12 or a stronger case, then the next logical thing for the judge, even though she's not going to want to do it, would be to hold her nose, close her eyes, and say, I think we need to have a hearing. And you bring in the jurors, turn off the camera, all that stuff. You don't have to embarrass them, and get the evidence. And then once you have the evidence, see where it goes. I mean, you could have the lawyers testify, obviously. The reality is, I don't know how you do this without the judge, if not testifying, at least making some kind of on-record representation, which the defense at that point either says we accept or don't, respectfully, Your Honor. You need to, you don't know what happens in that conversation. And I'm not suggesting corruption, but that conversation could be important for another reason, because it precedes the bus ride. Okay. And there's a fair argument. And if I'm the DA, I would want that addressed, because if they were upset on the bus, were they upset with the judge? Now, did they have the courage to speak to her? I don't know. But what if there are jurors who are looking at each other and doing head nods like, you, or what do we do? Or, I don't know. Wouldn't you want to know at a minimum what the judge, not what the jurors say was going on and what was said? Yeah. Yeah. Do the old Vinny the Chin thing,
Yeah.
what are you talking about? So it's not on there, no one knows. But these are all important things.
So
There's a comment here. What would the defense be asking if they objected to the mistrial?
That's a good question. Well, I mean, this is all legal mumbo jumbo. What they would be saying is, hung on what? Can we get some clarity?
We get a vote.
That's all they'd be
see
doing.
the tally.
And look, could they defense have done that? Yes. And Massachusetts has a very interesting thing in that Rule 27 that everyone's been overanalyzing. In the comments, it does say if there is a partial verdict, which there is reason to believe now there was, based upon the representation of these jurors, right, through the lawyers, it must be published, meaning entered. Now, of course, we have a factual concern over, well, what does that mean? The DA saying nobody said anything, so that's it. But the defense is saying it couldn't be entered because they didn't know how to do it. So are you supposed to just ignore that? I don't know how you can ignore that. I don't know how any judge with a conscience.
I mean, I look at voting. You know how like voting, when they look at the ballots, because maybe the machine didn't read it the right way, so someone has to look at it. And sometimes they even call the person and say, did you mean to vote for the person that we think you voted for? Like they even bring the people in to confirm it. That's what this is to me. It's like, we just we want to confirm how you actually voted on this. Like it shouldn't be that hard.
I don't know how a judge, in her own private mind, in her own private chambers, never mind what she thinks of the lawyers, never mind what she thinks of Karen Reed. She was a legal aid attorney, okay? And that's not a disparaging thing. That means she spent the majority of her career fighting for underprivileged people who she was literally the last line of defense to protect their rights, okay? And that doesn't just go away, okay, completely when you do that for a living. And when she's sitting there thinking this through privately without the courtroom lights and all that, I don't know how you basically get to the point where you say, we got the Tui Rodriguez charge. They came back. I got the note, didn't show it to the lawyers, didn't solicit any input, didn't ask anybody anything, read the mistrial, dismissed the jury. Now this is coming up, 4 jurors. DA is saying they never objected. And she's going to say 4 jurors, allegedly, right? And by the way, she doesn't think that Jackson and Yannetti are making this up. She may not care for them. I assure you she respects their skill. That's probably why she's not fond of them, because they are that good. It's that sometimes that happens, right? But is she really going to say, I'm not going to just gather evidence and see whether they acquitted her, and then if she gets tried again and convicted, she's okay with this? I find that very hard to believe. I do. I don't think even this judge, who everyone wants to believe is like every which way till Wednesday corrupt, which I don't necessarily believe. I don't think she's a friend of the defense, but I'm not like, there's a difference. I'm sorry.
I agree. I hope she does the right thing.
I don't think that she literally would want to see Karen Reed, if acquitted, convicted for what she was already acquitted.
Why did she, sorry, I apologize. Why did she declare an all-out mistrial? Then would be my question, is just that, having said that, why would she not, dismiss the first count 1 and count 3. Why would she allow that to continue on like this? That's
Oh,
I think like yeah, go ahead. Yeah.
Yeah. Because no, she's not paying attention and thinking, because this is how we do it in this courtroom. The same way about the verdict sheet initially. This is how we do it. And
Yep.
anytime you're trying to get an explanation for rationale from anyone in power and their response is because this is the way we've always done it, that's not a good answer. I mean, I
Yeah.
said this somewhere else, I think last week. I mean, segregation was the law of the land until 1954, and the argument was this is how we do it. That's not a good answer.
Yeah, that's a good point.
Sometimes the way we do it, you have to look a little deeper, and I don't think she gave it 2 thoughts. I don't think it was corrupt. I think it was just, what's for lunch? I want to get out of here.
Yeah,
negligent judge.
I'm gonna have
Yeah.
a cocktail. I'm gonna get a Shirley Temple
Maybe.
with
I
a
mean,
whatever.
maybe
Crab walking hour.
Yeah.
maybe negligence, maybe, it's happy at, well, it's going to be
There's
happy
also
hour
this
again.
part. This comment came up. Said Bev didn't said don't fill out the forms. This is what she said, until you have reached a verdict on all counts.
Well, this should matter because it goes to the heart of the confusion with the jurors. And again, all the defense is asking for right now, yes, I know they're saying you should enter judgments of acquittal on these counts, but they know that's not how this is going to work. Okay. They know that the way this works is the next step, which is getting real evidence to support the hearsay affirmations. Okay. And this comment here is part of that analysis, which is, don't we want to know what happened and if there is an honest to God miscarriage of justice? Because that has a lot to do with, I believe, based on what you've seen from the jurors, they didn't know what they were supposed to do. And it resulted in them not clearly communicating a verdict of acquittal on a murder count. How does that not bother everyone?
Yeah, it bothers me. Someone wanted to know if the jury could send affidavits directly to the court themselves if if Canoni denies the hearing.
No, because if she denies it, she's saying, I don't need it. Like, I'm finding there's nothing to do. Now, if the jurors then go rogue, which last time we spoke, I think I said, I think they would. And I don't think they're going to be sending them to the court at that point. I think they're going to be sending them to NBC, CBS.
Yeah, come on this show or any
Boston
show.
Globe.
Yeah, we've
Yeah,
got
that's
a million YouTube shows that will have you on.
absolutely. I mean, I think that's what they would do. And it's not because they're bad people, but if you're a juror in this case, okay, you just dedicated 2.5 months of your life.
Exactly.
And in essence, nothing officially at the moment was accomplished. Okay, that's bad enough. You attempt to correct it in the best way that you can. And the response you get from the DA is, who gives a rat's ass what they say? These people are morons. They don't know what they're doing. And if they wanted to do it, they should have checked off the box. How pissed off would you be? On top of the fact that it's going to eat your conscience if something terrible happens, such as her even being subjected to a retrial, never mind acquitted or convicted. If she gets retried on a murder case, it's going to cost her another $500,000 to $1 million.
Yeah.
For nothing.
Exactly. We're starting to run out of time. We're going to be back on a new stream at 7 p.m. with hopefully the Canton Select Board meeting, which is going to be on Zoom tonight. I hope they don't kick us off. I have a funny feeling they're going to try to stop us from broadcasting that tonight.
They have moved the Canton Select Boards no more COVID. Everyone understands it back then, but because of the incident or the embarrassment from last week, they have now moved everything to Zoom.
Yes.
So how
even the broadcast, like they're not even able to broadcast it on cable community television like they usually do.
I'm not a government type, civics lawyer or whatever they are, public law, that kind of thing, but that's got to violate some kind of sunshine law. how do people speak at the meeting if they want to be heard?
Zoom. They get on Zoom.
Well, so the link is like publicly available.
Yes, exactly.
I may have to hop on this thing myself tonight.
When is
Yeah,
this?
I hope not
feel
too
like
many people get
people
on
like-
there, because then
Yeah.
like people like me that want to stream it get shut out. That's the
Oh, I
problem.
see what
It's
you
like
mean. Yeah. Is
a
there a
lot
limit?
of times they don't have enough accounts. Like,
Oh, okay.
and so this may actually even limit the participation tonight. I mean,
Jeez.
I just think this is going to be a fiasco tonight. We'll see what happens, but
Yeah.
I'm predicting this will be a fiasco tonight. We'll see.
I'll stay out.
And I
I'll
wanna
stay out
ask
of
you
it
guys
then
a
if
few
that's the case.
questions about this, because Canton Select Board, they did that. So that's going on. The McAlberts also put out this, I don't even know, like I saw one of the troll accounts put
Oh,
it
that
out.
letter.
Yeah, they got this letter with
We,
like
the citizens of Canton, and it's
going
almost like
after
a
Rita
Declaration of
Lombardi. What
Independence.
do you guys think about it?
Well, at
I
least-
read it. Go ahead. No, you go. You go.
Yeah. Well, at least Grandpa Eclipse is on the thing. Grandpa Eclipse is back.
Peter,
That's right.
Peter
My
Hennessy.
name's on this, and my wife too.
I'm hard. I'm
I
old
thought-
and hard.
I thought it was like a Declaration of Independence. That it was like, we, the United Citizens of Canton. And then, it's funny because somebody posted this thing. And so now naturally, you just have to scroll through the names and see what do you see. None of the usual suspects signed it. Do they think, we have to be above this? We don't want our names associated with this?
It's funny who did sign it. Did you notice Elizabeth Proctor and
Yeah.
Courtney Proctor were
Well,
on
they
there?
have
And
no
Cour-
shame.
well, one of them used their like the maiden name or something. They used the other name. It's funny.
They need a TED talk. The wife and the sister. Do we have 2 minutes for?
Yeah. Oh yeah.
Look at the man. Instead of blaming the world, look at your husband and brother. Okay, he's a corrupt cop. He's not a good cop. That TikTok video of that cop's wife was brilliant. Have you seen that?
No.
Somebody shared it a week ago. It's a woman from Florida, I believe, who is a police wife. Just gave a takedown for the proctors about where you're shifting the blame.
I gotta
Instead
see
of
that.
defending him, he screwed up. And if he's a real man, he'll deal with it. And he's not a victim. He's not a good police officer. He did a terrible job in this case, even separate and apart from the corruption. Or he ordered a tow truck before he ever saw the car. Okay. He never took a picture of the car. That's not good police work. Okay. Waiting to find taillight pieces one day at a time is not good police work, which also begs the question. If you found a taillight piece like you claimed, which I would say is not true, the first time, wouldn't you break out the shovels and say, let's dig like today and find it all? Anyway,
It makes sense, wouldn't it? Make too much sense, maybe.
So he's ruined. He's going to be terminated. We know that. He's embarrassed himself. He's embarrassed his family. But the more they act like this, they're just going to hurt his kids, and let him fade away as a footnote of scandal. And the more they this idea that they think writing letters to the governor of Massachusetts is going to help is so cringe, so tone deaf, and just what a sense of entitlement. I mean, okay, Proctor is like political. He's like an atomic
Radioactive.
bomb.
Yeah,
Yes,
it's radioactive. And it's so like not with reality too. Like it's like you think like emails to the governor generally don't do shit no matter what it is. But on this, it's like no way is she going to listen to that crap.
Leave you with two last thoughts about why they should maybe sit this one out too. Wasn't the sister the one who got the suicide text?
Yep.
Agreed.
Yeah, she did.
And you are the one who then said, yes, she ought to kill herself. And you teach young children.
Yeah.
You, ma'am, should be fired. Okay. You shouldn't be telling people and being an advocate, because it's just going to end up making you look worse. And if my kids were in your class, I'd pull them out of that school.
Seriously, those two, like Courtney and Elizabeth, they're both risking their own futures.
They
Like
are,
the
well,
more they speak out, the harder it is going to be for them to be employable in the future.
teacher
Like,
of young,
and we already know they're going to have to support Mike. So
a
I mean,
teacher of young children with special needs wishing suicide is, you know what? It's hard not to feel bad for them because, you know, they love their brother and husband, but he made his bed and he's got to be a grown man and deal with a grown man problem. And think about your families and kids, but they see that he did nothing wrong. So I got to tell you, I don't have nearly, if any, sympathy for them like I did. But when I found out that she was also wishing that a presumed innocent criminal defendant, who is probably actually innocent, by the way, that you were wishing suicide upon her, and you're a teacher of young kids. That's, you know, they have powerful unions too. They're not quite the police unions, but they're big. That's terrible. And I can't believe the parents in that class haven't started a campaign of saying, why is this woman around my kids? Because that's just gross. So maybe sit it out.
good advice. Good advice. And especially like try to contact the governor. I mean, the Post Commission, I think maybe taking this up this week too. The Thursday morning, I'm going to be broadcasting the Post Commission hearing meetings too. And I think that might have to do with them.
Call the colonel, because yes, they're going to say, you're right. Michael was a good trooper, a good-hearted man. And like, we don't have enough problems with the other ones that, you know, he's going to bring down as well. And you know what? The other thing, maybe if they're big on helping him, they could have given him some more advice, which is when trial came by, shut your pie hole.
Yeah.
He didn't testify like I said he shouldn't. His process would have gotten dragged out much longer because he admitted the wrongdoing. At that point, they're like, if there it is, he would have gotten paid much, much longer, probably months. He could have been looking for a new job. He could have thought this out. But these people are so tone deaf, so deluded, and so self-unaware that they just think, oh, he'll talk his way out of it and everyone will be fine.
So funny. You gave the best free advice to him and he didn't listen. I wonder if the defense isn't listening to you because, like you said, a lot of the things that you said were in that filing. Do you think they might be listening and kind of sponging off some of your ideas on this?
Okay, that's an honor. That's not that's not like legal intellectual property, whether they are or they aren't. The reality is, I think people who do this for a living and are real lawyers, these aren't unique ideas, but exactly. You know, certainly that would be great if they were.
Yeah. Excellent. Maz, do you have anything you want to bring up on anything we've been discussing right now?
I do. Mark Bederow is awesome. It's just great always to hear his advice on this stuff, especially when, you know, responses, motions come out, you know, your way of just talking about this and breaking it down for us, as well as fielding some questions. A lot of times when I ask questions to you, it's questions either I have or I think many of us may have, and you answer them very well. So thank you for that. And overall, 22nd's coming quick. It's 6 days away, and I'm concerned about the judge still and just the way she is. A lot of times, anytime the defense makes perfect sense and says things within the levels of legality, it just seems to get either over her head or swept under the rug, and that's my big concern going into the 22nd. So hopefully she'll be favorable to the defense for a change, and hopefully maybe dismiss counts 1 and 3 once and for all, and just not let at least those 2 counts drag on. And essentially, if this continues on, then only count 2 is on the paper this time. And that's
I hope it's quick because I have a dentist appointment that day at 2:45. Push the last one back for Karen Reed. I'm like, I gotta get this. Like, I want to get the implants done. Like, it's like the last step, you know. And I'm just like, no way. I'm not canceling dentist again.
You can just put the earbuds in when you're there and just listen while things are going down.
Probably, but I don't know if I'll be live broadcasting it like I usually do.
Yeah, I know what you mean.
Probably some people might be mad at me. We'll see. I'm going to start at 2, and then I'll probably end it right at 2:45 on the live broadcast. You know, when I stream that thing, and hopefully people don't get mad. But what are your final thoughts tonight? We'll start with Mazza since we're about to break. Or maybe those were your final thoughts. I guess
Yeah, those are my
that was
final
probably
thoughts.
it.
Yeah. Yep, we can move. Yep. To
All right.
Mark. Yep.
And what do you think, Mark Bederow?
The cynic in me says the judge is going to do the wrong thing and just end it. If she does the right thing, it'll drag this process out for some time. So if the defense ultimately is going to get what they want, there are several steps that have to be taken. The only evidence that was even filed are hearsay affirmations. That's never going to get you the final relief. So despite what they're ultimately asking for, you have to look carefully at what's happening and look at their original motion. They want a hearing. They want an evidentiary hearing. They want to present evidence to demonstrate firsthand through jurors and whatnot what happened, and hopefully then make a very strong legal argument with real evidence, not quote unquote hearsay. And if that's going to happen, that process could take weeks and weeks and weeks. So, and if that happens, nothing's going to get resolved on the 22nd. If it gets resolved next week, then she's denying it. And if she denies it, it's pretty much over, because there's not going to be an appeal ever. So as frustrating as it is, and what'll happen is it will turn into a PR issue. And this is a prediction because I don't know anything. I don't know who these people are, but I think jurors are going to come out of the woodwork. And I think they're going to string this along and make this worse. So realistically, it's kind of a win-win for the defense. I mean, obviously, if she was acquitted, it makes you want to throw up the idea that anyone could ever be retried for anything that they were acquitted, and that a judge would not even be willing to listen to that evidence when there's a good faith basis to believe it's worthy of exploration. So I think that would be horrifying if she really did that. I guess we'll have to wait and see. But based on, recent behavior, I kind of feel like she may, but the papers they filed today made that much, much more difficult for her.
I'm glad you brought up earlier that it even goes beyond America, like the double jeopardy is Magna Carta. When was the Magna Carta? Like 1500s or something? Like
1215.
Yeah, I mean,
That goes back.
Yeah, no, I mean, look, it's obviously most of the American system is based on English common law, although there's certainly differences, but everybody knows, whether you don't have to be a lawyer, you don't have to be over the age of 7, probably. You don't have to live in America. If you said, so here's a hypothetical: woman gets tried for murder. Jury says not guilty. DA says, okay, we're going to try her for murder again. How do you feel about that? I feel like if I walk down the hallway when this is over and ask my 8-year-old, she's going to say, they can't do that, can they? I mean, I just think it's that
basic.
Yeah. And to the extent, maybe I'm dating myself with this, to the extent that nobody knew that previously, I feel like in the O.J. Simpson situation that it became everyone
Clear.
knew.
Yeah.
Because, he almost certainly was guilty, but he was acquitted. And that was the end of it.
Exactly. There's only one way you can go after him after that is civil suit, which isn't the same as a criminal,
right.
And that's a different deal. We had a quick question come in on the Cash App. They said, can the jury sue the state for emotional distress?
No, but they can scream and yell and embarrass if that's what they choose.
And that's what they should do. They should come on this show. We'll bring every one of them on. We'll give them like an hour plus.
Would be stunned that if not at least one or more jurors, if this goes that way, don't want to be heard, because if for no other reason, I think the DA's response is offensive to their involvement. But more importantly, I think it's going to eat at their conscience. I mean, if the theory is that they can retry her for murder, and they know, those 12 people know, we don't really know, they know that they acquitted her, and everybody's saying, we don't care what you did. Even though the judge, if you recall, when she gave him that charge, there are no 12 people who can do this better than you. All they're doing is telling those jurors that was all bullshit. That's all a pattern jury instruction that we just read. It's all fluff. None of us really mean it. We're just saying it because they're telling you we did do our job and nobody wants to hear us.
Thank you so much for being here, guys. I want to thank Mazza Media again for joining us, and attorney Mark Bederow. Thank you guys so much for being here. And hopefully, like, we don't get bad storms. Did you have anything come through in New York yet, Mark?
Not tonight, although today was over 100 degrees. It was hotter than hell here. So it was bad today. We had some incredible storms a few days ago. I mean, like tropical craziness, but no.
That's what we're expecting in Massachusetts tonight. Some
still
crazy
nice.
storms coming in about 9 p.m. So people be careful. And after 9 p.m., be careful, especially in Eastern Mass and Central Mass. There's apparently some tornadoes even possibly coming through tonight.
Jeez.
It's been like the same way, 90 plus degrees. It's been really hot. So I hope everyone is safe and get plenty of liquids. And we'll be back at 7 with the select board meeting. Thank you so much, Mazza Media and Mark Bederow. Follow them both. Bederow Law on Twitter, X, Mazza Media on Twitter and YouTube. Make sure you subscribe. How many followers you got now on YouTube, Mazza?
So I'm closing in on 8,000. I just crossed the 10,000 mark on X as well yesterday, which was pretty awesome.
Wow, congratulations, bro.
Yeah, thank you.
Awesome.
Yep.
That's when you start to get to the 10,000 point, it's like that's when you know you're getting somewhere. So
yeah, exactly.
Good work.
And quick thing, the popcorn sales I think hit about $53,000, which is about $26,000 raised off the 50% for Karen Reed. So everyone that bought popcorn, great job. I know I did, and that is absolutely awesome. So I just want to thank everybody on behalf of everybody that ran a store, Kelly, Paul, Nick, everybody out there. Just great job pitching in and doing what you did, and enjoy your popcorn when it arrives. So.
And you can still donate too if you want to support the Karen Reed Defense Fund, freekarenreed.net. There's also the Turtle Boy Defense Fund. You can just Google it. It'll pop right up. Give, send, go. Thank you guys so much for being here tonight.
Thank you.
Talk to you soon. Bye.
You too. And we're the Young Jerks. I think I got all the Venmos and all that stuff taken care of tonight. We just had one from Holly come in. Thank you so much, Holly. I really appreciate it. Just want to make sure that I'm not missing any super chats and all that. I want to thank our moderators. I want to thank Miss Shorty. She just gifted 10 Young Jerks memberships. Congratulations to all those people who just got the new memberships. We've never done a member show or done any benefits, but we may. I think that may be coming. I'm trying to work on something for you guys. If it happens, then the member event will happen. We'll see. But I very much appreciate everyone who's been supporting us. And I'm just going through to make sure I didn't miss. I think I got everything. I think I got everything tonight. Gonna check the chat real quick. Did I miss any super chats? Let me know. So again, we're going to be live at 7 p.m. hopefully. A new stream on YouTube or Facebook, wherever you're watching us, at 7 p.m. with the Canton Select Board meeting. We may take some phone calls tonight too. I think I may keep this going tonight. We may have Rita maybe call in, maybe John Como, and I think there may be something going on there. We're going to have some, how do you say this, feet on the ground in Canton tonight. And there may be something that we air tonight. We'll see. Could be a protest. People are not happy in Canton about what they're doing. So come back at 7. Let's see what happens. We're going to have a fun night, hopefully. Canton Select Board. They're playing the Zoom game. Yeah, hopefully it'll be some fun tonight at 7. You know what? This may be the only best thing about the Zoom. Zoom usually does have better volume. A lot of times I don't even have to turn the volume up on the Zoom. So someone said, let's hope the select board volume is better on Zoom than in person. Might be the only good thing about tonight. Yeah, I guess Turtle Boy did cancel his show tonight. He's going to be on tomorrow night. So we may stay up a little later tonight and do some shows. Do some calls. We'll see. I felt like there was something else I wanted to tell you guys, and I can't remember right now. But maybe I'll remember it later. Because, like I said, we'll be back at 7 p.m. So please check back in a few minutes. 11 minutes. We'll see you then. I want to thank you all for supporting, subscribing, all of that. We just got over 35,000 subs on YouTube, which is just unbelievable. I can't believe it. Thank you so much. We'll see you at 7 p.m. Thank you, everybody.